take much of your lordship's time, Mullahs. Mullahs, my learned friends have argued on 2-3 counts. Number one, they say that their cultural rights under 21 have been impacted by this demographic change. That's one. Number two, that Article 14 has been violated for the reason that while this protection is given to migrated people in Assam, it's not given to others. And number three, they say that Section 5 and 6 are frozen in time in the Constitution. Article 5 and 6 are frozen in time. And therefore 6A cannot in fact have been enacted. Broadly speaking, these are the three broad submissions. Now, there's a fallacy in each one of them, and I'll demonstrate it right away. Mullad's migration of peoples and populations is embedded in history. It cannot be mapped. No migration can ever be mapped. And if you look at the history of Assam, you'll realize that it's impossible to figure out who came when. Assam originally was a part of Myanmar. And it was way back in 1824, after the British Mullahs conquered a part of it, that a treaty was entered into by which Assam was handed over to the British. And I'm talking about 1826, 1824, 1826. You can imagine the kind of movements of peoples that must have taken place in the context of the then British Empire. And if you jump to 1905, you will have the partition of Bengal. And in the partition of Bengal, East Bengal and Assam became one. Indeed, at that point in time, Bengali language was forced to be taught in schools. There was a huge opposition to that. So this interaction between the Ahom people, who are the original inhabitants of that part of Assam that was taken away from Myanmar, integrated with the non-Ahom peoples. And therefore, the interaction and the absorption of the Bengali population in Assam has a historical context. In 1911, Mullahs, it was reversed. The partition of Bengal was reversed. But they belong to the same area. The ethnicity was different. The language was different. And all these problems were created by the British. Because when the independence of India took place, East Pakistan, which is now Bangladesh, was carved into a separate country. And the exodus happened because of the fact that the ethnic minorities, linguistic minorities, as well as the majority community in East Bengal, in East Pakistan was not willing to stay there. The problem on the West Coast was entirely different. On the western border was entirely different. Because on the western border, it was the Hindus who were coming into India, not the Muslims. The Muslims were given the choice to go there. That's why the date 19th of July. If you not come on the 16th of August, Mullahs, we are people who have been displaced from Lahore. My maternal grandparents were killed. So we came here immediately on the 16th of August. But there are many people, Mullahs, who came here afterwards. and they had to be given refuge. So therefore the 19th of July date, therefore the mechanism. That would never have happened in Assam. From East Pakistan, there was no such. All the minorities wanted to come into India because it was originally a part of India, part of the British Empire. So when this partition took place, naturally, people of Indian ethnicity, Bengali ethnicity, their language would want to come. So, Malaj, to try and argue a constitutional point, which is the point I'm getting at, to say that this has changed the cultural ambiance of Assam is constitutionally invalid. Because you cannot attribute to one event, this to one event. Nor is the court, Malaj, has the wherewithal to do so. You shouldn't even start this exercise. More important, Malaj, I have a fundamental right to move from one place of the country to another. So immigration or migration from one place to another is a fundamental right. Can some...
Within the country, of course.
No, it doesn't matter, Malaj.
No, but within the country, this right really doesn't extend to people who are not Indians to enter.
Malaj, but they were India. That's the point. They were Indians. On that particular day, they were Indians. When Malaj, please, in 1971, when this happened, the war happened, Malaj, and Bangladesh was created. They were Indians before that.
Who was Indians?
Malaj, please, please.
No,
They were.
What's the argument?
Malaj, what happened? Pakistan was created.
They were all part of undivided India.
Correct. They were correct, but they were
the government of India.
Correct. Malaj, when Pakistan was created, naturally, people would like to come. Malaj, in 1951, people would like to come. Malaj, Bengalis would like to come. Hindus would like to come. That's the point I'm making, Malaj. A constitutional argument can't be made because it happened in 1951 that they came here. Therefore, Malaj, it changes the cultural environment of Assam. That's not a good argument constitutionally. For the simple reason, Malaj, the argument has to be applied in the context of demographic change. Demographic change can never be the basis of saying that my culture has been impacted. Can never be, as a matter of constitutional law. Why, Malaj? Because Part 3 of the Constitution in enforcement of rights. Article 21 is the preservation of rights. 29 is the preservation of rights. There's a constitutional distinction between the two. They are people of different cultures, different traditions, maybe different language. They're entitled to preserve it. Nobody has infringed that. Their argument is it has been infringed demographically. An argument that has no basis in the Constitution. They have to show violation.
Mr. Sibal, there may be some problem with this because an argument about demographic change as affecting culture can never be made within the territory of India. For instance, somebody in a particular state, take for instance, there's this huge migration which is now taking place in our IT centers. People can't say our culture is being changed because of this huge migration.
Maharashtra, Manoj, labor coming from.
Because for the purpose of citizenship law, as Attorney General has very beautifully put it in his submissions, India is one entity. Correct. So no one state or no people in one state can say that, look, by virtue of the fact that we are having an influx from other states, that our culture is being affected. Too bad. That's what the Constitution presupposes by postulating Article 19(1)d. You rightly said that, there's free movement. But this applies within the nation.
I agree. Let's kindly see 29 now.
Can the people of a state not say, suppose the union were to say that we are going to resettle, say 20,000 refugees or 25,000 refugees in a particular state. There may be substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
But I'll answer that. See 29.
You cannot have a challenge at all.
Well, that's 29. Just look at 29. Just have a look at 29. If I may, let's read it. Any section of the citizens residing in the territory of India, or any part thereof having a distinct language, script, or culture of its own, shall have the right to conserve the same. No problem. Which part of their petition says that their right to language, script, or culture has been impacted? That's not even their case. So how do you bring 29 into it? The submission that I'm making is this demographic change happened because of historic reasons. And these historic reasons don't relate only to 1947, after 1947. These historic reasons are etched in history right from 1824. And it would be difficult for the court, bullets, to identify as a matter of fact that this happened only after 1947.
According to you, this flux was happening much before that.
Much before. It's part of history, Malad. And well, actually what happened in 1971 was the second partition of India. In the sense that Pakistan was, East Pakistan was obliterated from the back, Bangladesh was created, and those people, those Hindus, and
That's not a second partition.
second partition of Pakistan. So therefore, because of that, these people came across. It's that second partition of Pakistan that resulted in part of this influx. And Parliament debated it, and I don't want to trouble your lordships. When Parliament debated it, Parliament said, we don't want to. Yeah. And this literature we've put in the compilation, Malad. In our compilation. I'll not trouble your lordships with it. The point I'm making is Malad, this second partition of Pakistan resulted partly in this influx. But the influx was happening, Malad, all along. But in any event, Malad, as a matter of constitutional law, they have to show as to what part of their language, what part of their script, what part of their cultural tradition is being impacted. And ultimately, what I heard the other side saying, and that's a political argument, what I heard the other side saying was, they have been even given the right to vote. That's nothing to do with 29. So, Malaz, what happened? Now, let's come nearer home, Malaz. Then what happened? In 1978, Malaz, the Janata Party came to power. And Malaz, there was a Janata Dal chief minister. And Malaz, as your lordship knows, Malaz, that government fell in 1979. Mrs. Gandhi then came to power. Now, what had been happening between 78 and 79, there were huge agitations in Assam by the student community. And if I may, Malaj, invite you, just note it, Malaj, there's a book called Modern Assam, which is part of the compilation, Malaj.
Where is that book?
Yes, give the page. Kindly, just at your leisure, read chapter 12 of that book, which is titled Waves of Popular Protest. Waves of Popular Protest. Just give the page, please, the PDF. It will give you the historical context of how this whole protest started. There was price rise, there was unemployment, And then part of it was attributed to the fact that there were people who had settled there since 1951. And there were protests against that. That, look, these are outsiders. So these are the others. And the agitation reached such a crescendo that it led to huge violence. I mean, the Delhi massacre in 1983 was as bad as any massacres that have happened since. In fact, the agitationers said, we would rather give our blood, but we will not give our oil. Why? Because production of oil was in Assam. And there was they stopped the production of oil. Production of oil fell. Only 3 places they produced oil: Gujarat, Bombay High, and Assam. Transportation was stopped. Killings took place. Children were killed. In 1983, Mrs. Gandhi decided to have an election. It was opposed. 2% of the people voted in that election. And a person with 17% won the election. There was again a huge protest. I'm talking about 83. Why this 85 happened? Then Mrs. Gandhi was assassinated in October. The demand was that 1951 onwards, everybody who was a non-Assami who had come in should be thrown out. This was not agreed to. Mrs. Gandhi got assassinated in October 1984. Rajiv Gandhi then said, let's try and compromise this issue. In the meantime, Praful Mahanta became the chief minister. And in the 2 years, 83 to 85, they got discredited. The movement, became weak. And the 85 Accord. Mrs. Gandhi always said, let's keep 1967 as the cutoff date. The learned solicitor rightly said, because of the 66 electoral roll. And 67 was the election. They did not agree at that point in time. But in 1985, when Rajiv came to power, he said, no, there should be give and take. And therefore, this cutoff date was agreed to. And therefore, the 1966 to 1971 period was dealt with separately, and the other period was dealt with separately. That's the genesis. Now, the first submission that my learned friend gave, he gave you population figures, those figures cannot possibly be relied upon one way or the other. Because you don't know the genesis of the migration. And even their figures show that after 71, the Muslim population has been reduced. Therefore, yes, the rate of growth has been reduced. So the point I'm making is I'm on the first point, of the Article 29 point. That has no constitutional basis. But we're not talking about people coming from outside or coming from inside. We're saying that in any event, in terms of 29, you'll have to show infringement. And their infringement is only change of demographics. That's why they show the population figures. Change in demographics cannot be the basis of an infringement of Article 29. Cannot ever be. Unless, it's very interesting. In fact, if you ask me, Assam perhaps is the most multicultural, multilinguistic, the most diverse state perhaps in the country. And culture. Diverse culture. Of the 10 or 11 petitioners that my learned friend pointed out, each of them represents a separate culture. Nobody says that that's been infringed. That's not their case. So it's a very slippery slope to address this issue on the basis of demographic change. But this is the march of history. You can't stop this. And at that point in time, Parliament said, why should we stop it? These are our own people. For those who Muslims who left India and went to Pakistan and they wanted to return India, there was a whole different process that's included in section 5 and 6, in Article 6. Whole different process. Because we did not want them back. Here we were welcoming them because these are people of our own ethnicity. So this was an act that was recognized by the then government and allowed to happen. But they did not realize the kind of opposition that will emerge as it did in Assam. It happened in other states, but it happened in Assam.
So essentially, the Assam Accord was that 71 onwards,
Yes.
Nobody will be protected.
Correct.
51 to 66 and 66 to 71, people who came in would be protected, basically.
That's right.
51 to 66, no questions asked.
Right.
66 to 71, you have to satisfy the...
That's correct. Now, if you look at Muller's really migrations this way, for example, when the Vietnam War took place, kind of the Vietnamese people that were settled, these are all foreigners. You look at the German Mullahs, the Turks Mullahs who have now been given citizenship, when the Germany tweaked its constitution. It's tweaked its constitution. It never allowed this to happen before. So Mullahs, Mexicans, there's a special provision of the Mexicans in the US. So the point that I'm making is that's the decision of the political process which allows this to happen and then makes a provision for it under the law. And there's no basis for challenging it other than Mullahs, other than the ground that it is discriminatory. But this was a non-discriminatory recognition, not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited...
Place of residence, yes.
Sorry?
Based on place of residence.
No.
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, Mullahs. I'm sorry. That is the test. That test was applied between 66 and 71. And your Lordship looks at the entry in list 1. It's entry 17 of list 1.
Yes, 17.
Which is citizenship, naturalization, and aliens.
There's no doubt that Parliament has a power. There's no doubt about it.
No, I'm not only... Sorry.
Entry 17 confers and read with 245, Article 245. Parliament undoubtedly has the power to legislate.
Correct. But they were not discriminating on the basis of residence. They were not discriminating anybody on the basis of residence. They were saying only if you're a resident will you get this through the process of naturalization. So then under no prohibited category. And well, there's another very interesting feature as far as Assam is concerned. Assam has 5 hill areas, scheduled areas that were created. And their autonomous councils, Mullahs. A lot of the minorities, Mullahs, never went to those scheduled areas. You can't buy land there. So they remained where they are. So the Muslim population percentage showed it had increased. So all these are very complex issues, Mullahs. How is this court going to determine all this and come to a conclusion that this is violative of 29? There's a place called Darang, Mullahs. A part of Darang was created as a tribal area. Mullahs. So the Muslim population only stayed in the other part, Mullahs, so that if you took Darang in its original state, Mullahs, the Muslim population would be less. But when the tribal area was considered, the Muslim population would be more. The point that I'm making is there are no judicial standards to determine all this. It will be a hazardous task, judicial task, for you to come to a constitutional conclusion that because of this, their cultural rights under 29, because 29 is preservation of rights. Preservation of rights assumes that there is a violation, and because of which I have a constitutional entitlement to say, issue a writ of prohibition, issue a mandamus not to allow them to violate. That's nobody's case. And it is therefore not solely attributable to migration. So that's on the 29th. Now, it's absolutely tenuous connection, as my learned attorney says. Absolutely tenuous connection. One has nothing to do with the other. Very, very, very. Now, let's kindly come to now the Article 14 argument. That's even more interesting. Now, I'll assume, Malat, that 6A is struck down. Now, if 6A is struck down, what happens? Bangladesh will not take them.
As we said, this will result in a group of stateless citizens.
Total statelessness.
The joint communique, which was issued by Sheikh Mujibur Rahman and the then Prime Minister, clearly says that Bangladesh will take back people who had come in after 25th of March 1970.
That's correct. So Malas, you cannot, as a matter of constitutional law, Malas, and again, if you go
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And if you go to my submission, well, just give me power of judicial review. I've dealt with it in 2-3 minutes. I'll just finish on this aspect. Kindly come, alerts, to volume 2, my submissions.
Yes, we got yours. The ones, yes, we've got your volume 2.
Volume 2. At my submissions start at page 19, but scope of judicial review is at PDF 23. That's all right. In fact, may I tell you, Lordship, another thing. While this agitation was taking place in Assam, many of the people, whether Bengalis or others, moved out of Assam because they were fearing that they might be killed or hurt. Many families actually migrated to other states. So, in fact, the migration to some of the other states, Madhur, is also attributable to what the uncertainty that prevailed in the state of Assam from 1978 right till 85. And then, Malad, as your Lordship knows, Meghalaya, Mizoram, and others. So, therefore, the Muslims the minorities would not have gone to Mizoram, Meghalaya, and other places, Malad. So, it seemed that the population here increased in terms of percentages. So, these are all very difficult aspects, Malad, to analyze and come to a judicial verdict. So, now if you look at Malad's PDF 23, if you just look at what Hannah Arendt said, right to have rights. That's the right to citizenship is the right to have rights. And I've quoted the page. I won't go to it, Mullas. And then your lordships will see laws should be interpreted, para 17. A, law should be interpreted in a manner that avoids rendering people or groups of people stateless. The international law norm against statelessness is to be found in foundational legal instruments, both see the Universal Declaration and the International Covenant of Civil and Political Rights, and Article 20 of the American Convention on Human Rights. And well, I've given some references there. Your lordships may have a look at it. And the idea is that courts should attempt to harmonize domestic law with international law. That's Visakha Malas has set that out. And lean towards upholding laws in cases where striking down would result in statelessness. And then citizenship laws should not discriminate on prohibited grounds. As citizenship is the right to have rights, and deprivation of citizenship renders individuals particularly marginalized or vulnerable. For reasons advanced above, courts should subject facially discriminated citizen laws to strict scrutiny. Is to protect individuals. So, Malas, this takes, and then Malas, somebody else in West Bengal or another state can say, you give me the same rights, but they cannot say, now you declare these as illegal, and therefore, where will they go? And Malas, the commitment to fence Bangladesh was made in 1985 itself. So 15 years and 23 years, 38 years have passed. The fencing has not happened. Should have happened. And this creates more problems for India, as your lordship said, because after 1971, what will happen? Children would have been born here. Can your lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Where will they go? So that's, I don't want to enter into that. It's another area altogether. So that takes care.
Equally, there is substance in this grievance that, on the one hand, we don't have an open border.
Yes.
We do not say that anybody from Bangladesh can come and settle down wherever they want in India. At the same time, if we don't take action to curb illegal migration, then it causes all these problems in India. The feeling in India that, look, the infrastructure is limited.
Absolutely.
Education is limited.
Absolutely.
Public hospitals are limited.
Yeah.
We can't allow for an unlimited influx.
Absolutely. No, you're right. And this is the problem. Therefore,
we passed that order, which we did this afternoon. What are you doing today?
It's the executive that is to blame, Malas. There's no doubt about it. And right from 85. And we create problems for ourselves. And then what happens is, Malas, it becomes the other versus us. This is the heart of the problem. It is no longer a cultural issue. It's a political issue. Others versus us. Who gets power? Why do you give them electoral rights? This is the problem. Don't give them the right to vote. So therefore, you in the process are creating divisions in society, whereas your preamble talks about fraternity. Now, what is fraternity, Malas? Live and let live is Article 21. Be and let be is secularism. That's what it is. And that's fraternity. And the entire argument on the other side is countering the concept of fraternity in the preamble.
So, Sibyl, how do you, I mean, this is not a question in the sense to tell you that you're wrong on this point, but just a little assistance. How do we sort of conceptualize subsection 2 of section 6A and subsection 3?
All right.
Subsection 2 deals with people who are in the electoral roll as on 1/1/1966.
Right.
They're all post 1951 people,
right,
but who are in the electoral roll as of 1/1/66. Right. That's why subsection 2 refers to the electoral roll of 1/1/66, 66 electoral roll.
Right.
The subsection 3 covers people who are not in the electoral roll of 1966.
Correct.
They came in later until 71.
Correct.
So what was the reason for protecting those whom they protected first in subsection 2? Was it that Parliament wanted to protect people who are now they've come on the electoral roll as on 1/1/66? So we say, all right, you have now been assimilated. We have already, whether you are legal, illegal, we sort of make a blanket conferment of citizenship. What was why these two bifurcations into subsection 2 and subsection 3?
I will try and answer that, Malas. There are two reasons for it. Number one, even those whose names were in the electoral roll, people objected to them. People objected to them, saying they got themselves into the electoral roll. They did not come here prior to 1966. That's why the whole NRC exercise has taken place. And at the end of the NRC exercise, do you know what the result is? Your Lordship asked that question, they should have told you the answer. The answer is, today there are 19.06 lakh people who are left out of and whose appeals are pending. That's all. And the majority of them are Hindus. So it's not as if nothing happened after 71. This exercise has been done and done in 8 years, Malas. Malas, that's why Justice Gogoi said, everybody will have to produce the legacy tree, legacy data. Who was your great-grandfather? Even those whose names were on the electoral roll. So in the NRC, every citizen, every person in Assam had to face the test. So in fact, from a statutory standpoint, what my lord is saying is right. From the actual standpoint, it's just the other way around. Because there were thousands of objections. Well, somebody didn't have a school certificate. Well, who gave a school certificate at that point in time? Then you had to show, no, my great-grandfather lived in that village. Then there had to be a linkage document. Then you had to produce somebody from a nearby village or the village in which you lived, and he came and made a statement, no, his grandfather was living there. So, Malaj, it may be as a matter of law for you to say that's not factually correct. Well, the whole NRC exercise was that all this may be wrong. And it was monitored by this court. And it ultimately found that the majority of the 19 lakhs were Hindus. 1,600 crores were spent in that exercise. So the point that I'm making is, Malaj, while your lordships asked me that question, the factual situation is in fact just the opposite. Because I don't want to bring any politics into it, because everybody objected to a particular, that he doesn't belong here. Of course, that exercise is still going on. But Malaj, therefore, it would be dangerous, and this is my respectful submission, to move into areas where it's difficult to come to a judicial determination. That's why 6A was a matter of policy. It was legislative policy pursuant to a political accord which sought to maintain a status quo subject to processes for those who came between 66 and 71. Yes. And if they do not formulate how 29 has been violated, why would your lordships go into it? So, but that's really the answer to your lordship's question. That everybody was questioned. It just so happened that once you're in the electoral roll, then you have a leg to stand on. But that was not the end of the story. It's not as if everybody who was on the electoral roll was accepted as a citizen. And then, Malaj, the argument that they owed allegiance to Pakistan, I don't understand that argument at all, Malaj. When I am born, Malaj, do I have an oath of allegiance to give? Or if somebody is granted citizenship, people don't give the oath of allegiance. When people came from what?
See, the upheaval, actually, as a matter of history, when did the upheaval start taking place in East Pakistan?
Upheaval started taking place in East.
No. The 66, I'm talking about the leading up to Bangladesh.
Lordship knows, after the Bhutto election in particular, but the fact of the matter is that those belonged to an entirely different cultural tradition. This was all part of Bengal, Malaj. This is East Bengal and West Bengal. So all this is the oppressive policies of Western Pakistan, so to say, or now Pakistan, right? And what is happening there to the Hindus today was sought to be done to the Bengalis. It's as simple as that. Who would want to stay there? But the impact of it, because they came this side, the impact of it was what happened in Assam later. But it's bound to limit resources. They were claiming that their education should be free. And then what happened? The tea plant, the tea planters came here much before 1951.
Operation Searchlight is initiated by General Yahya Khan on the 25th of March.
Yes.
Now, interestingly, Section 6A, 25th of March, 1971 is not the commencement of the provision. It's the end of the provision.
End of the provision, yes.
Right?
Yes.
So, if at all, one would anticipate that the influx would take place around or after 25th of March, 1971.
It didn't.
What the statute does is to go back 5 years to 66, 1166.
Yes.
What is the reason for that 1166?
Malaj, as I told you, by 66 because of the electoral roll. After that, Malaj.
The electoral roll of the electoral roll of 1166,
Yes,
which was used for conducting the elections of 67,
yes,
covered all those people who had entered India prior to 1166,
yes, yes,
right?
yes,
That is covered by 6A2.
yes.
Just see how it is. I'll just tell you how 6A is worded. 6A2. All persons of Indian origin who came before the 1st of January 66 to Assam from the specified territory,
Right.
now bracket, very important, including such of those whose names were included in the electoral rolls for the purpose of the general election to the House of the People held in 1967.
Correct.
That is to say, the 1967 election was held on the basis of the electoral roll of 1166.
Correct.
That covered people who had come in prior to 1166.
Necessarily, Malas, people may have come prior, but they may not be in the electoral roll.
You're right. I'm not talking the exclusion.
Yes,
But 6A2
yes,
covers people post 1166,
yes, yes.
right? I can understand 6A2. 6A2 says, whoever now we have included in our electoral roll, we'll give them citizenship. Therefore, anybody whose name was in the electoral roll of 1166 got the benefit of citizenship, but under which provision? Under 6A2.
Yes.
Now, what is the logic for 6A3?
But I'm saying, Malas, many people who had come in even earlier, but they had no evidence to show. Malas, kindly, there are many people who came in earlier. No. The war is later. War is not then. It's 65 war happened.
6A2 you cannot justify it on the ground of the Bangladesh liberation.
No, I'm not, Malas. There is a Pakistan war, Indo-Pak war of 65.
1965, there was a war. There is the Indira Gandhi Pact. Jeep and Indira Gandhi agreed. Pact. Those
Election took place in East Pakistan. Mujibur Rahman won. There was unleashing of violence. He was not allowed to be sworn in. That's what happened.
70.
Yes, in December 70. That's the violence that happened. He was not allowed to be sworn in.
But that is 3 months before our cutoff.
That's why, Malas, that's precisely why I'm saying, Malas, that 3 months has been also excluded, as your lordship sees now, from March onwards. Therefore, Malas, it has nothing to do. This exodus didn't happen from East Pakistan or Bangladesh at that point in time. This is all prior.
I mean, there's one way of dealing with it, which is that Parliament has legislative domain over what cutoff date to adopt.
That, of course.
Unless the cutoff date is palpably arbitrary.
That's correct. That's correct.
You normally allow Parliament.
But apart from that, Malas,
I mean, that can always be a judicial mantra, but we are trying to figure out what was the logic.
But Malas, it's not just a cutoff date. It is to prove, your residence.
Sorry?
It's not. That's all right. Said Malas, a person who got 17% of the 2% vote, Malas won the election. So that was rejected by the people. So it was, but Malas, the 66 onwards, you had to show evidence that you were resident for 10 years.
All right, Mr. Zibal.
So
thank you.
therefore, that's over.
Anything else?
No, I don't think so. I just want to. No, one second. I don't want to waste the court's time. Else? Anything else? And therefore, there are only two aspects: the date and the territory. No, I don't think so. Also note, Miller, the tea plantations, the traders came much earlier. So the date and the territory are the two aspects, Miller, which are considered by deeply obliged.
Thank you, Mr. Zibal. Yes, Ms. Jaising.
Huh? No, my lord is only confining to 6A. Why are you worried? They were worried they'll go beyond 6A. Of course not. We haven't argued that.
No, we are very clear in our mind. We have not heard the,
Because it has
Mr.
other
Diwan has not
applications.
argued that, Mr. Solicitor has not argued anything
Yeah,
beyond
because
6A.
2024 is round the corner, Mullah, then nothing should be.
I don't think that this.
No, I'm saying.
2024 has no relationship with the constitutional being.
No, I'm saying nothing should be said.
But Mr. Sibal, equally, we must make it clear, you probably all have, you've got the drift of it, irrespective of what happens to 6A, and our minds are open until the last word is said by Mr. Diwan and the others. Irrespective of that, we intend, because it's a constitutional court, on what is being done to take care of the problem of illegal migration. That's something which I think we have to address in this judgment. And we do propose to address it because irrespective of what happens to their plea on 6A, I mean, the cause of the petition, there is a great deal of there's a great deal of substance in what their grievance. I mean, look, what are you doing to our state?
Therefore, I will not very categorically and candidly say that I am not trivializing their problem.
Neither are
I am answering only the constitutional question.
Over that.
This is a serious question, and as a custodian of fundamental rights of all citizens, the Lordship.
We have to address that in any case.
We must, all of us must. No doubt about it.
Yes, Ms. Jaising.